Corporations can be charged with crimes, even though they aren't people. This legal reality affects businesses of all sizes and can result in massive fines, operational restrictions, and lasting reputational damage. Corporate criminal liability allows prosecutors to hold companies responsible for the illegal actions of their employees and agents. This doctrine treats corporations as legal entities that can be found guilty of criminal offenses when certain conditions are met. For a corporation to be criminally liable, three key elements must exist. First, a corporate agent must commit a criminal act while working for the company. Second, that agent must be responsible for all elements of the crime. And third, the illegal action must be intended to benefit the corporation rather than just the individual. Interestingly, a corporation can be found guilty even if the owners or shareholders had no knowledge of the criminal activity. If a manager directs employees to illegally dump hazardous waste to save disposal costs, the company benefits and can be held liable, regardless of whether top executives knew about it. Corporate crimes typically fall into several categories. Antitrust violations occur when companies engage in anti-competitive practices, like price fixing or market allocation. Corporate fraud involves deceptive practices to gain financial advantage. Securities violations happen when companies mislead investors or manipulate markets. Environmental crimes are also common, especially among manufacturing corporations that improperly handle hazardous materials or pollutants. Prosecutors consider several factors when deciding whether to charge a corporation. The pervasiveness of misconduct throughout the organization is a major consideration, especially when illegal behavior occurs at higher levels of management. A history of previous violations suggests a pattern of disregard for the law. Attempts to obstruct justice by hiding evidence or intimidating witnesses significantly increase prosecution likelihood. Corporations that fail to take remedial action after discovering misconduct or refuse to cooperate with investigators are also more likely to face charges. While individuals can be imprisoned, corporations face different penalties. Monetary fines are the most common punishment, sometimes reaching billions of dollars for serious offenses. Courts often require restitution payments to victims. Corporations may be placed on probation, with court-appointed monitors overseeing operations. They might lose professional licenses or government contracts essential to their business. The reputational damage from a criminal conviction can lead to lost business opportunities, declining stock value, and damaged relationships with partners and customers. In some cases, prosecutors may offer alternatives to criminal charges. Deferred prosecution agreements postpone charges pending compliance with specific terms, like fines and reforms. Non-prosecution agreements allow companies to avoid charges entirely in exchange for cooperation and corrective actions. These alternatives aim to hold corporations accountable while avoiding collateral consequences like mass layoffs or bankruptcy. Corporations can reduce their risk of criminal liability through preventative measures. Implementing clear codes of conduct establishes expectations for legal and ethical behavior. Regular employee training programs on compliance issues help prevent misconduct. Internal reporting mechanisms like whistleblower hotlines enable early detection of problems. Dedicated compliance officers can oversee these efforts and ensure the company meets its legal obligations. Corporate criminal liability serves an important purpose in our legal system. It ensures that businesses cannot profit from illegal activity and encourages them to monitor and prevent wrongdoing within their organizations. By holding corporations accountable for the actions taken on their behalf, the law provides powerful incentives for companies to operate ethically and within legal boundaries.